Good afternoon. I'm Ian Forrester. As you can hear from my accent, I was born and brought up in Scotland, and after about 40 years as a legal practitioner, I was nominated by the UK to be a judge in the General Court of the European Union. And among our responsibilities is appeals against European Commission competition decisions, as well as other things. But it's because of my background in competition law that I was here today participating in a panel about enforcement of competition law and judicial review. I found it extremely interesting. All around the table, 40, 50 countries with experience of competition law enforcement, the problems, the difficulties, the opportunities, the setbacks, the successes. Very interesting. And then I was able to share my own thoughts, partly as a practitioner long ago and partly as a judge today, about the adequacy and intensity of judicial review. When an expert agency says, for example, hybrid cars and electric cars are in the same product market or are not in the same product market, there will always be a basis for that. It won't be fiction. It'll be a carefully thought through determination on the basis of some evidence. Now, it might be very controversial, and the question for the judge is how far the judge should second guess what the public authority says. And there's a lot written on that subject, which has gone in every possible direction. And although there have been judgments of our Court of Justice, and the Human Rights Court in different cases, it still is a controversial field. So my submission was, in deciding whether the judicial review system is appropriate, you should look at the entirety of the process from start to finish, from the first initiation of the complaint to the final disposition on appeal, and look then to see whether the judicial review that's built into that is adequate to confer legitimacy upon the enforcer. Other things we talked about were confidentiality and the fact that excessive claims of confidentiality can be a real blockage to judicial efficiency, but that parties are often willing to have a look with a view to solving those problems practically and voluntarily, without insisting that the judges examine each of 100 questions of supposed confidentiality. We noted round the table that almost every country that spoke noted the delicate choice to be made. There's a public authority, it's expert, it's given a task, it has looked at a question, and it's reached a conclusion. And how wrong, or how apparently wrong, must the public authority be before a judge feels it's appropriate to intervene and grant judicial review? That's a very important question, and I think it's going to be argued about for some years to come. The question of technical expertise on the part of the agency to be set against the right of the enterprise to have its day in court, to have judicially examined the validity of the conclusions made by the public authority. Very interesting day. I'm very glad that I came.